Good afternoon from Vienna, or good morning or good evening, depending on where you might be joining us in the world. My name is Martin Reggie, and I am an Associate Crime Prevention and Criminal Justice Officer at the Chemical, Biological, and Radiological Terrorism Prevention Program of the Terrorism Prevention Branch of the United Nations Office on Drugs and Crime. It is indeed my pleasure to welcome you to today's webinar, the 10th and final in a series on key aspects of the International Convention for the Suppression of Acts of Nuclear Terrorism. First, let me express UNODC's gratitude to the European Union for enabling this series of important virtual discussions on the convention and for its partnership in supporting our long-standing efforts to promote ICSANT. The convention serves as a cornerstone of the global nuclear security architecture, representing the first internationally legally binding instrument to criminalize the illicit use of radioactive sources. However, it would not be enough for states parties to this instrument to criminalize the conduct set forth therein. Provisions also need to be in place to ensure that domestic courts are effectively in a position to adjudicate them. Today's webinar will focus on the jurisdictional aspects of ICSANT. Effective jurisdictional provisions are essential to ensuring that individuals who commit certain offenses involving nuclear or other radioactive material, devices, or nuclear facilities cannot evade justice by exploiting gaps between legal systems. One fundamental objective of ICSANT is to avoid a situation where the perpetrators of terrorist or other criminal acts, or those who plan to support them, can escape justice because the countries in which they are physically present decline their jurisdiction. In today's discussion with Professor Patrick Keenan, who you will hear from shortly, we will expand and examine the topic of jurisdiction, including aspects such as mandatory and optional bases of jurisdiction established under Article 9 of ICSANT, the principle of extradite or prosecute, conflicts of jurisdiction, and practical considerations for states seeking to implement these provisions in their domestic legal frameworks. With that, allow me to begin with a brief overview of ICSANT as a refresher for those who might not have been able to attend our previous webinars. So just briefly, as it relates to ICSANT and a short historical background, negotiations were called to address gaps in the international legal framework for preventing and responding to acts of nuclear terrorism. ICSANT was drafted by an ad hoc committee established by the UN General Assembly in 1996. Negotiations lasted around 10 years. The convention was adopted by the General Assembly in April of 2005 and opened for signature in September 2005, eventually entering into force on 7th of July 2007. The depository for this instrument is the United Nations Secretary General, and it currently stands at 127 states parties. ICSANT is one of the 19 international legal instruments against terrorism, which have common elements across them. It's primarily an instrument of international criminal law in that it establishes criminal offenses for certain unlawful and intentional conduct involving radioactive material, devices, or nuclear facilities. Offenses range from use and possession, coupled with certain intents to damage to nuclear facilities, and states must criminalize illicit conduct under ICSANT's Article 2 through their national legislation and establish jurisdiction over the conduct, which is the focus of today's webinar. The principle of extradite or prosecute, which we will also discuss, helps to eliminate potential instances of safe havens. And the instrument includes mechanisms to facilitate international cooperation, which allow for the effective investigation, prosecution, and adjudication of relevant crimes, again, to deny safe havens to these alleged perpetrators. We should talk about, of course, what ICSANT does cover and what it doesn't. For an offense to fall under the scope of the application of ICSANT, there needs to be a transnational element. Article 4 of ICSANT also lays out exclusions from the scope of the instrument. Activities of armed forces during an armed conflict are not covered under this instrument, as they are accounted for under other regimes such as international humanitarian law, activities undertaken by military forces in the exercise of their official duties, again, are covered by other rules of international law, and the use or threat of nuclear weapons by states is covered by other disarmament, arms control, and non-proliferation regimes. One key message as well is that ICSANT only applies to acts by non-state actors, so something to remember as well. Article 1 of ICSANT lays out the definitions of the type of material that is covered. Specifically, radioactive material is understood as nuclear material and other radioactive substances which contain nuclides which undergo spontaneous disintegration and which may cause death, serious bodily injury, or substantial damage to property or to the environment. Nuclear facilities are also defined under Article 1. Nuclear facilities are defined as any nuclear reactor or any plant or conveyance being used for the production, storage, processing, or transport of radioactive material. This means, for instance, that a van transporting a radioactive source is considered a nuclear facility under ICSANT. Finally, devices are described as any nuclear explosive device or any radioactive material dispersal device, or radiation emitting device, which may, owing to its radiological properties, cause death, serious bodily injury, or substantial damage to property or to the environment. A dirty bomb, for instance, would fall under this definition. ICSANT establishes offenses involving radioactive material, radioactive devices, or nuclear facilities, as mentioned on the previous slide, given that they have been committed unlawfully and intentionally, that is to say, in the absence of a legitimate justification and deliberately. These offenses range from those listed on screen, from illicit possession or use of nuclear or other radioactive material or radioactive devices to damaged nuclear facilities, and include also a series of ancillary offenses. The list of offenses, again, can be found in Article 2, but it's important to know that the act itself isn't enough. It needs to be committed with a specific intent. Those include the intent to cause death, serious bodily injury, or substantial damage to property or to the environment. Or, in the case of use, the intent to compel a natural or legal person, an international organization, or state to do or refrain from doing an act, which is the so-called terrorist intent. The focus of today's webinar, jurisdiction, I won't go into too much detail, but simply want to list the jurisdictional provisions under Article 9, already to prime you for Professor Keenan's presentation. Again, not going into great detail as the presenter will here, but mandatory jurisdiction is covered under Article 9, so instances where a state must exercise jurisdiction, and optional jurisdiction, which, as the name would suggest, different bases where a state can elect to include the exercise of its jurisdiction. I also want to highlight under Article 9.3, a new function which UNODC is undertaking, specifically under Article 9.3, states must, upon ratifying, accept, approving, or acceding to this convention, notify the Secretary General of the United Nations of the jurisdiction that they have established under their national law in accordance with paragraph 2 of Article 9. Should any changes take place, the state party concerned shall immediately notify the Secretary General. As of 27 October 2025, UNODC is in charge of this function to receive the above-mentioned notifications, of which we will make available on the UNODC ICSANT website. And I'll highlight, too, that image that you see on the left is a new tool specifically on jurisdiction that we at UNODC have developed under our EU project. The convention also contains the principle of extradite or prosecute under Article 11. This helps to eliminate any safe havens. Article 13 talks about specifically extradition, mentions that offenses must be considered extraditable offenses in all existing and future extradition treaties among the states parties. It allows for the modification of provisions that are incompatible with the convention, and where there may not be existing bilateral agreements, allows for the convention to be used as a legal basis for extradition. As mentioned, international cooperation is also a key hallmark of the CT instruments and of ICSANT. Again, you'll see not only extradition, but different mechanisms that allow for mutual legal assistance, for the exchange of information to prevent, detect, and respond to offenses and conduct under the convention. The designation of competent authorities and liaison points to relay information related to these acts with other states parties, preventative measures, and post-crisis situations, which allow for the assistance of various international organizations in returning or rendering harmless certain material. We did mention mutual legal assistance. Again, just to highlight under Article 14, the degree specified is that states parties shall afford one another the greatest measure of assistance in connection with investigations or criminal or extradition proceedings. Coming to the end of the presentation, I just wanted to highlight a few of the preventative measures in post-crisis situations, specifically that ICSANT does allow or does mention measures to prevent or counter the preparation of offenses. It's covering a spectrum here to not only respond to them after they're completed, but to prevent them before they take part. This is done, again, through the exchange of information among those states parties with international organizations in detecting, preventing, suppressing, and investigating offenses under the convention. And lastly, the protection and safety of radioactive material and devices that allow for the storage and return of material seized following the perpetration of an offense. To close, I just want to mention the work that we do at UNODC. It covers a wide spectrum from outreach and awareness raising for different key criminal justice officials, and also capacity building activities to help those such as frontline officers, judges, and prosecutors better understand their role under the instrument and how they can make effective use of it. We develop capacity building tools such as manuals and e-learning modules and fact sheets that we encourage you to share with your colleagues who might not be able to join today's webinar, and also work to provide legislative assistance to effectively incorporate the provisions of various instruments, including ICSANT, and a whole host of other tools. A few of them are listed on screen for you here. They're available on our UNODC website in all UN official languages, as well as several other languages. Just to highlight, again, that recent, as part of our EU project under the toolkits on ICSANT, one specifically does focus on jurisdiction. You'll find it available on our UNODC website, so I encourage you to visit that, as well as any of the other tools you see listed here that may be of interest. You'll find the website listed on screen there, and a QR code which will take you to it. It's a tool that's regularly updated on a weekly or bi-weekly basis. You can learn about all the different programming that we do at UNODC to support adherence to and implementation of not only this convention, but others within the CBRN legal framework. And again, access those technical assistance tools and other information on our activities. So I want to thank you for your attention and now move to the focus of today's presentation, which is the presentation by our speaker, Professor Patrick Keenan. I'm pleased to welcome him here today. Professor Keenan is the Albert J. Harno Professor of Law at the Illinois College of Law. He is also a professor with the Center for Global Studies, Center for African Studies, and the Lemon Center for Brazilian Studies of the University of Illinois at Urbana-Champaign. An expert in human rights and international law, he has published articles and book chapters in leading law reviews and academic volumes. His scholarship has been cited by the United States Supreme Court and other federal courts. At the Illinois College of Law, Professor Keenan has taught courses on international human rights, international criminal law, public international law, counterterrorism law, and the ethical responsibilities of lawyers. He also created and for 10 years directed the Human Rights Law Clinic, in which students at the law school work directly with lawyers and advocates in Africa and the Caribbean on important human rights cases. Before coming to the University of Illinois, Professor Keenan defended indigent criminal defendants facing the death penalty at trial, on appeal, and in habeas proceedings. Professor Keenan received his JD from Yale Law School and his BA from Tufts University. He clerked in the United States District Court for the Middle District of Alabama and served in the Peace Corps in the Democratic Republic of Congo. If you have any questions, we encourage you to email them to unodc-icsant@un.org, and we will attempt to answer them during the webinar or provide responses by email. I would now like to invite Professor Patrick Keenan to discuss the jurisdictional aspects of ICSANT. Professor, if you would share your presentation, we're happy to give you the floor. Thank you.
Thank you, Martin, and thank you to everyone who's here. I'll share my presentation momentarily. First, I want to commend UNODC and Maria's team, and of which Martin is an important part, for this important webinar series, and also commend the EU for their longstanding support for this work. I think it's tremendously important. I'm especially pleased to participate because Martin is one of my former students, one of our very, very best former students, and seeing him do this important work has been as gratifying to me, and it's also one of the good reasons to be a professor, as you see your students go on to do wonderful things. Just a couple of caveats before I share my presentation. One, I'm speaking in my personal capacity, not as an employee of the state of Illinois, and I certainly don't speak for UNODC. So if I say something that is an error or seems wrong, you should blame me and not UNODC. And also, I am a law professor. I'm not a technical expert. You all are the technical experts, or many of you are. So I will leave those issues to you. I'll speak only about the legal issues. So with those caveats, I will share my screen and then talk about jurisdictional issues. So right now you should be seeing just the introductory slide. If you're not seeing that, Martin, please let me know right away.
No, we see it.
Good. So here's me, and here's our work plan for today. I'll talk about ICSANT's requirements, and then I'll talk some about treaties and jurisdiction. So some of the conceptual issues, and they're important because I think they really illuminate the logic of ICSANT and the way that it can work and is working in a way that I think balances a lot of important issues. And then there's time for questions and discussion. And also, because I'm a professor, I will leave you with some homework. And you don't have to turn your homework in to me, but I will encourage you to submit that homework to Martin or Maria or others on their team. So that's our work plan. And of course, questions are welcome, and Martin gave you already the email address to send those questions. So ICSANT starts, the jurisdictional provisions are implementing the criminal provisions. So it works in multiple steps. It defines which crimes are covered, and it gives states parties their instructions on when they should establish jurisdiction. And this is a balance of deep respect for states and state sovereignty, and allowing different states to, according to their own legal traditions, establish jurisdiction, while also acknowledging that there is responsibility on states to enact and fulfill their promises, the promises they made for those states that are states parties to ICSANT. So it starts, the jurisdiction provisions are primarily in Article 9.1 and 9.2, and I'll just talk about those quickly, I think, and then we'll talk about some of the deeper issues. So the mandatory jurisdiction provision is principally Article 9.1, and it says that states must establish jurisdiction, shall take measures as may be necessary to establish jurisdiction when the crimes that are defined in Article 2 are committed on the territory of the state, on an aircraft registered in that state, or on a vessel flying that state's flag, or when the offense is committed by a national of the state. So that's obligatory. States have promised to do this. And this is not a self-executing treaty, which we'll talk about briefly in a moment. This is a treaty that requires states to take additional steps after they become states parties. Article 9.2 lists the optional cases. So when are states allowed under the treaty to establish jurisdiction? And so listing these as optional, I think, is wise because it does allow for more flexibility with states. So states can decide that how they want to structure their own jurisdiction within their own legal traditions and how that fits in with their own criminal codes or their own jurisdictional provisions in other parts of their legal codes. This is me speaking personally, not as someone who's a representative of UN ODC, of course. This is optional jurisdiction, but I think the logic of ICSANT suggests that this is also very important. This can help states that establish this optional jurisdiction can go a long way toward closing any accountability gaps and reducing the number of safe havens for malign actors. So this optional jurisdiction allows states to establish jurisdiction when the victim is a national, when the victim, or if we can say it in that way, is a state's facility that's outside the state or an embassy, when the offender is a stateless person but has his or her habitual residence in the territory of the prosecuting state, and I'll talk about what that means in a minute, or when the offense is designed to coerce a state to do something. So Martin talked before about trying to compel a state to do something, and when the victim or the offense is committed on board an aircraft is operated by the government of the state. So just to summarize, these are the mandatory cases. Territorial jurisdiction, vessels or aircrafts flying the state's flag, and offense when the offense is committed by a national of the state. And these are the optional cases. States nationals, states embassies and facilities abroad, stateless persons to coerce the state or on a government aircraft. And again, that's just a summary. It's not a substitute for the full text, of course. So this is, as I said before, this is a non-self-executing part of the treaty. So self-executing treaties are treaties which can be directly applied in the domestic courts of a state. Non-self-executing means that the treaty requires an additional step, additional domestic legislative implementation before it may be applied in the state's domestic courts. And so the criminal provisions of ICSANT are non-self-executing. So what the drafters intended and what they wrote in this treaty is, here's what the crimes are, here's when you can establish jurisdiction. Now you states go forth and do this, and states promised to do that when they became states party. And so this is important work that states are required to do because the cases would be prosecuted in states domestic courts. So that's just the very basics of jurisdiction and ICSANT. So now let's look a little deeper into the concept of jurisdiction. So jurisdiction is just power. It's the power of a state to exercise legal authority over a person or property or a situation. And criminal jurisdiction, I think, is conceptually the easiest to understand because criminal jurisdiction is what all states have criminal jurisdiction in some ways, and this treaty directly establishes that and envisions that. And so this power of jurisdiction is divided into three different dimensions, or three different, sometimes it's thought of as kind of species of or types of jurisdiction. And these three different types of jurisdiction are important because notice what ICSANT is talking about. ICSANT only applies to transnational crimes, and it only applies to non-state actors. So in almost every case, there will be more than one state that can decide that, or that could theoretically have jurisdiction. So understanding the different types of jurisdiction and where they are in in ICSANT, I think, is important. So these are the three types: jurisdiction to prescribe, jurisdiction to adjudicate, and jurisdiction to enforce. And jurisdiction to prescribe is the authority to enact laws that regulate conduct or places. And so criminal laws, when a state establishes a criminal law, it's exercising this jurisdiction to prescribe. Jurisdiction to adjudicate is when this is the state's authority to subject someone to their judicial process. And so this is important, and it's an important part of ICSANT because ICSANT requires at least some assistance with investigation of cases. And so states are exercising the jurisdiction to adjudicate when they investigate a case or gather evidence. And finally, jurisdiction to enforce, or sometimes called jurisdiction to compel, is the state's authority to compel a person to comply with the law or appear for judicial process. And I think of this as the ends of a criminal case: the beginning when someone is arrested or detained, and the end when someone is punished. So those are the times when jurisdiction to enforce is most important. When states are exercising this power, though, and especially when states are exercising this power in cases when multiple states may have a strong interest, either a claim for jurisdiction or the offender comes from one state and the target is in a different state, this can lead to conflict among states. So when are states allowed to exercise this jurisdiction? This has been a long-standing issue in international law. It's something that has been litigated. It's something that's been addressed. And so now there are 5 accepted reasons that states can exercise jurisdiction under international law. And what this means is international law says to states, when you're establishing jurisdiction in your domestic courts, here are the reasons that we will allow, that international law says are permissible reasons to use this power. So state A can use this power even if it means that state B may also have at least some claim to jurisdiction. And so these are the 5: territory, nationality, what's called passive personality, the protective principle, and universality. And so universality is not directly relevant to ICSANT, and it's something I'll just briefly mention toward the end. But the other 4 are relevant. And so jurisdiction based on territory means that states have the authority to create laws that apply to people and property within the state's territory. This is a bedrock principle of international law. This is the least controversial reason that states can exercise jurisdiction. And so we see in ICSANT in Article 9.1 and 9.2, 9.1, there's mandatory jurisdiction over offenses on the state's territory, vessels or aircraft, and optional jurisdiction over offenses by a person stateless person with his or her habitual residence in the state. These are examples of territorial jurisdiction. So one of the mandatory provisions and one of the optional provisions that is on this very firm ground as a basis of jurisdiction. Jurisdiction based on nationality, this nationality principle means states have a strong interest in ensuring that their nationals are not committing offenses abroad when they're outside the prosecuting state. So international law recognizes, and states around the world respect, the idea that when a national of state A goes abroad and commits an offense, state A has a strong interest in prosecuting that person. And so ICSANT also recognizes or establishes mandatory jurisdiction over offenses committed by the state's nationals. And I said a moment ago establishes. What ICSANT does is it requires states to establish jurisdiction over offenses committed by that state's nationals when they're outside the state. The next kind of jurisdiction is jurisdiction based on the nationality of the victim. And this in international law is known as passive personality jurisdiction. But you can think of it, I think that it's conceptually pretty easy for us to imagine that states have some interest in ensuring that their nationals are protected or treated fairly when they're abroad, and if they're the victim of a very serious crime, then that state will have an interest in prosecuting the offender. So ICSANT says, states, you have the option to establish jurisdiction over offenses committed against your nationals or your facilities abroad. And again, what you see on the slide is a summary. You should go back to the treaty for the detailed language. And finally, and this is the basis of jurisdiction that I think, or a basis of jurisdiction that has created in some ways the most controversy in recent years, but for nuclear terrorism related crimes, it's not particularly controversial. And that is the protective principle. And states are permitted to punish a very limited set of crimes committed outside their territory by non-nationals when the offense threatens the integrity of the government or the state's vital interests. I think if we look at Article 9.2 of ICSANT, there's optional jurisdiction over offenses designed to compel the state to do or not do an act. And so that's something that law professors would argue over as to whether this is truly based on the protective principle. But I think this idea that states can prosecute an offender when that offender is committing a very serious crime to compel the state to do something or not do something, that is not likely to generate a lot of conflict with other states. So why do we care about this? We care about this because we care about what reasons states have for exercising jurisdiction. ICSANT envisions that these reasons will be sufficient and that states will establish, either must or will or may establish jurisdiction based on these reasons. And we care because states have already agreed in international law that these are permissible, acceptable reasons to establish jurisdiction. What that means is there's a very low likelihood of conflict between states when states are using jurisdiction for, or they're establishing jurisdiction in this way. So this is, to me, ICSANT has based its jurisdictional requirements or options on what is bedrock international law that's unlikely to cause any sort of friction among states, at least these provisions. I'm not talking about other parts of ICSANT. So just to summarize, mandatory jurisdiction based on territory and nationality of the offender, optional jurisdiction based on nationality of the victim and on the state's vital interests. So there's a couple other places where jurisdiction comes up. So in Article 14.1, ICSANT says states parties must assist one another. So this is mandatory with investigations and evidence gathering. And with transnational crimes, this is absolutely essential. I teach international criminal law and counterterrorism law. State cooperation, interstate cooperation in investigations is essential to any successful prosecution. And the lack of interstate cooperation can really lead to problems in prosecutions, even when there is consensus that the prosecution is appropriate. This requires states to establish the jurisdiction to adjudicate. This Article 14.1, I think, I would read this as another example or another instance in which states parties are required to establish jurisdiction. And it's another reason states should, at the very minimum, fulfill their promise to establish mandatory jurisdiction. Another part of ICSANT that I think is very important and that Martin mentioned earlier is is ICSANT's requirement that states either extradite a suspect to another state with jurisdiction or prosecute the suspect themselves. And to comply with this promise, states parties must first have jurisdiction under Article 9. So states are not able to prosecute if they decline to extradite for any reason. They're not able to prosecute unless they've already established jurisdiction. Article 9.4 is the provision that establishes this requirement, and you can see it uses the language shall, not may. So shall take measures to establish a jurisdiction over offenses, so that it can prosecute, states can prosecute when the state does not extradite that person to any other state party with jurisdiction. So this extradite or prosecute provision, I think, is essential to closing the accountability gaps or reducing safe havens, as we mentioned earlier. So there are some additional issues related to jurisdiction that I want to talk about, and then we'll have time, I hope, for questions if there are any. So the first issue is, we saw the term habitual residence before. What does that mean? The next thing is to think about objective versus subjective territorial jurisdiction, which can be a little tricky. And then I just want to mention very briefly the idea of universal jurisdiction. ICSANT does not have universal jurisdiction. These offenses are not subject to it. But we can see that there is a quasi-universal framework in ICSANT that I think shows the logic of ICSANT. So habitual residence is in Article 9.2. And so what that article says is states may establish jurisdiction over the listed offenses from Article 2 when the offense is committed by a stateless person, so not a national of any state, who has his or her habitual residence in the territory of the state that wishes to prosecute or establish jurisdiction. I think this is important if you think about the real world of cases where there's people move around a lot, there may be stateless people or people who have, because of their movements or because of their actions, are considered stateless. So what does habitual residence mean? It's not defined in ICSANT. So we, as a professor, as legal analysts, we look to other contexts. And so in other contexts, which usually comes up in tax or child abduction or child adoption, I should say, this term is defined according to domestic law, so the law of each state. There's not one and only one definition in international law. And so we can look to those other contexts to get a sense of what it means. And so there isn't one definition, and I don't view it as my place to tell any state party how they should define this. But the factors that are commonly considered, and I think are relevant both to the object and purpose of ICSANT and from the other provisions in international law, are to determine if a state is the habitual residence of a potential offender. States look to physical presence in the state. Is that person in the state? How strongly are they connected? So do they have a driving license in the state? Are they employed in the state? Do they get public benefits in the state? Those kinds of factual connections. There is some states, when they, under domestic law, they look at the intent to remain in the state. So are there indications, like enrolling children in school, that would indicate that that person intends to remain there? And also, just factually, how long has the person been in the state? So again, this is left to states to determine what habitual residence means, but there is a cluster of factors that are the most relevant. And when states are establishing jurisdiction under ICSANT, I think it would be wise to include a provision stating habitual residence is defined for the purposes of ICSANT according to the following factors, or according to the definition elsewhere in our domestic law, something like that, so that states are being clear that this is not an issue that they're leaving completely unconsidered. The next thing is jurisdiction based on territory. So now imagine an attack or one of the crimes that's listed in Article 2 is initiated from the territory of State A against a facility in State B. And again, only non-state actors we're talking about. So we're not talking about the states as wrongdoers. We're talking about the states as places where the person could be prosecuted. So who has a legitimate claim to jurisdiction? The territoriality principle says objective territorial jurisdiction means that when there's a big impact on State B, so if they're the intended victim, or they are the victim of a completed attack, then the impact on state B creates a substantial connection to state B, and therefore state B has territorial jurisdiction. Similarly, if there is sufficient preparatory work that going in state A to initiate the crime from state A, even if it's completed elsewhere, then state A has a substantial connection to the offense, and so state A has a claim. So that leads to multiple states having legitimate claims. This is not uncommon in the law. This is something that comes up. It's not. It doesn't mean that there's some flaw in the law. And so, how should states decide who prosecutes? What you see on the slide is a description of the processes used. I'm a law person. I'm not a politics person. So the typical way this is addressed initially is cooperation and diplomacy, which is outside my remit, of course. But when there are pre-existing agreements in place, so extradition provisions or pre-existing cooperation agreements that can make the resolution of these claims much easier, the state with physical custody of the accused often has a very strong claim and the stronger claim. The state where most of the evidence is located, if there is one state that has the overwhelming majority of the evidence, or if there's a completed attack or a completed crime where there's catastrophic consequences, then the location of the most significant consequences. Again, these are for the prosecutors and state officials to determine. The law doesn't dictate the outcome. Instead, the law helps shape the way that those who are making this decision would go about making it. So I mentioned before universal jurisdiction. So universal jurisdiction is a concept that allows states to exercise jurisdiction over a very small set of crimes, conceptually small, but there's a very long list of specific crimes committed anywhere in the world by anyone, even in the absence of a connection to the prosecuting state. The offenses under the ICSANT and other counterterrorism instruments are not part of the universal jurisdiction regime, but they offer what we could think about as kind of quasi-universal jurisdiction. And so the way that I think of this is the logic of ICSANT is to eliminate safe havens, to promote as much accountability as possible. So what it initially, the initial part of it is the states becoming states parties to and adhering to ICSANT, establishing all the types of jurisdiction that are contemplated under ICSANT, through cooperation and mutual assistance, which is important. It's important to the legal and jurisdictional issues that I mentioned, but as you all know, it's important in many, many other ways, and to fulfill the extradite or prosecute requirements. And the way that I see the quasi-universalization in ICSANT is you go from having just a few states where that are engaged in ensuring that there are not there's full accountability, to more states, to finally more states. The more states that do it, the greater the protection is. So elimination of safe havens, the elimination of accountability gaps requires every state to do its part. It's not that ICSANT does not contemplate that there is one state that will be the police officer for the entire world. So I'll end with homework, as I mentioned before. And so the first question is, part of the homework is your state a state party to ICSANT, and has it established mandatory jurisdiction over the offenses? Secondly, has it established optional jurisdiction over the offenses? These are both important to closing the accountability gaps and ensuring that there are as few gaps as possible in the wall between civilians and governments and non-state actors who wish to commit these kinds of crimes. Next, does your state's law include all of the aspects of the crimes, including threatening or attempting to commit an offense and demanding nuclear material by threat? And this matters especially for crimes that could have potentially catastrophic consequences. ensuring that prosecutors and investigators have the tools they need to address these crimes before they happen or when they're in the planning stages. And then finally, do you need model legislation or any tailor-made legislation? UNODC has it, can partner with states, and is happy to partner with states. I especially commend the tool on jurisdiction that ICSANT has developed with the support of the European Union. I think that's terrific, and I think will help any state that is either looking to establish mandatory and optional jurisdiction in the first instance, or to look back at its statutes or its laws to ensure that there are no gaps, even if the state has established some elements of the mandatory or optional jurisdiction. So I'll end with that slide, and I'll end where I began with my thanks to UNODC, to Maria and her team, and to Martin for inviting me, and I would welcome your questions.
Thank you, Professor Keenan. Really interesting and enlightening presentation that I think laid out the heart and the crux of the jurisdictional elements of ICSANT. So I mentioned just again to the audience, if there is any questions, you're free to submit them by email to unodc-icsant@un.org. But just to highlight something and to maybe start us off, during your presentation, you had mentioned the protective principle and perhaps why it's controversial in other cases. Why might it be controversial in others, but perhaps here not?
So again, I'll just remind everyone I'm speaking just in my own capacity. So I think it's controversial. Let me start with why it's controversial in other cases and then why I think it's not controversial in this case. So it's controversial in other cases because a state can essentially declare our state has a vital national interest in something, and whatever that thing is. And because we have a vital national interest, we will exercise jurisdiction over crimes that are that affect that interest. And so there have been states, my own country, the United States in particular, so I'll just mention that without mentioning other states, that have sought to extend that principle. And so that instead of looking at only at interests that would be viewed as vital national interests by every state in the world, they have, I think, controversially kind of tried to extend that principle. The reason I don't think it's controversial in this case is because there are no states that disagree with the idea that nuclear terrorism should be a crime. There are no states that I'm aware of that think nuclear terrorism should be perfectly permissible, or that combating nuclear terrorism is not a vital interest of the state, or ensuring that the state isn't coerced or compelled to do something because of the threat of nuclear terrorism. So when the protective principle is used to protect vital interests that every state in the world, I would suggest, would agree are vital, it's not a controversial use, in my view. When states have sought to lengthen the list of vital national interests, so you get a very long list that would allow the state to reach into other states to seize or detain suspects, etc., that's when the controversy has arisen, not when it's a very obvious, when I would say nuclear terrorism is a very obvious vital national interest.
Thank you. Additionally, Article 9 of the Convention identifies the two categories that you mentioned, and together with Article 9.4 and 11 reflect the principle of extradite or prosecute, which, as you mentioned, plays a critical role to allow states, as many states as possible, to have the power to exercise jurisdiction. But can you perhaps explain how those provisions again work together to prevent safe havens and ensure accountability for offenses under ICSANT? Are you better to have more states attempting to exercise jurisdiction instead of fewer?
So I think that it's a really good question, and I think it's a really important part of ICSANT. So I can tell you, in my ideal world, every state party would establish all the mandatory and optional jurisdictional provisions. So when that happens, you end up with as few safe havens or accountability gaps as possible, so that states, when they're making the determination as to where to prosecute, are making that determination not from a position of having no legal authority to prosecute, or from having to try to determine, can we change our law at the last minute, that kind of thing. Like that's not a good way for states to engage in any sort of legal or legislative process. Instead, if as many states as possible have established jurisdiction, that means when it's time to extradite or prosecute, the states can make that determination based on evidence reasons or based on legal reasons, not based on the idea that, or the fact that, one state has neglected to establish mandatory jurisdiction or optional jurisdiction. So, as I said at the very beginning, I think ICSANT is, to me, one of the reasons I think it's such an important, I mean, there are many reasons, but it's such an important treaty, is it really balances the idea that states have the idea of respecting state autonomy and state sovereignty, while also saying to states, you have a responsibility. And so that responsibility is ensure that you have jurisdiction over the offenses and that you have all the kinds of jurisdiction we've spoken about, so that when it comes time to determine where is best to prosecute a person, that's based on law and evidence. It's not based on the fact that one state has an accountability gap and states are scrambling to find a way to prosecute someone.
Thank you. And I believe maybe there's time for one more question. I don't see any in the chat, but I wanted to perhaps ask, ICSANT doesn't create an international criminal court or tribunal, so responsibility rests with national criminal justice systems. In light of this, what practical issues do you think states parties should consider in ensuring that the domestic courts are set up and able to adjudicate the offenses under ICSANT?
So, just at the risk of repeating myself, I think that the fact that ICSANT is relying on domestic courts means that ICSANT is putting a lot of weight on states parties to look really in a clear-eyed way at their own laws to ensure that there are not accountability gaps. So first and most obvious, the jurisdiction, the provisions that we've talked about. But I think there are two other things that are especially important. One is that states should be establishing cooperation regimes. So how will states cooperate in the event that there is an offense or an attempted offense or a threat of an offense? So when those exist ahead of time, that makes it easier to cooperate. In addition, extradite or prosecute, as we've talked about, the extradition provisions and the way that the extradition mechanisms should work, those can be established, I think, clearly and easily ahead of time. Putting all those things together will allow for states to prosecute when they have the evidence and when they have the physical custody of an offender. It also avoids the issues that we've seen. I'm someone who's wrote a book about the International Criminal Court, and I still spend a lot of time doing work in that area. But anyone who works in that area is, I think, you'd be foolish to deny that there are controversial issues about having one court that has jurisdiction over crimes in many, many countries. And so ICSANT kind of avoids all of those issues, but it only avoids those issues and those controversies if states fulfill their responsibilities, fulfill the promises they made when they became states parties.
Thank you. Well, with that, I will move to the conclusion of our webinar. It's been very useful and engaging, and I think helped us better understand the jurisdictional elements of ICSANT. I want to once again thank you, Professor Keenan, for taking the time to join us here today. And also I want to thank the audience who's been with us throughout the webinar series. We welcome your feedback and any questions or comments, which you can forward to UNODC, again, to email at unodc-icsant@un.org, and we can share them with Professor Keenan afterwards. I want to again thank the European Union for its financial support to UNODC, which makes events like today's possible, and for sustaining UNODC's longstanding efforts to promote the convention. Although we're ending here with the 10th and final webinar, you'll find recordings of all webinars on our UNODC ICSANT website. We've covered a lot of ground with other topics and other experts, so I would encourage you to visit that and to view those as well.
Martin, to interrupt, I see someone has raised their hand. Mr. Paredes.
Okay. Yes, don't think I'm able to give the floor.
Mr. Paredes, if you could send your question per email, we will address it and get back to you.
Thank you, Maria. Yes, we'll if you can address it, we will. Again, that email is unodc-icsant@un.org. But again, you'll find recordings of all webinars on our UNODC ICSANT website, and also you'll find all of the information on our efforts to promote the universalization and effective implementation of ICSANT. With that, again, I want to thank you again, Professor Keenan, for joining us. Thank you to the audience, and close today's webinar and the webinar series. Thank you, everyone. Thank you.
Thank you. Bye-bye.